Good evening to one and all. Uh, it's my great pleasure to have you all here to this distinguished public lecture. Uh, it's I extend my great and warm welcome to Dr. Abhishek Singhvi, uh, who is the Senior Advocate Supreme Court of India and member of 5A for the Rajya Sabha, which is the upper house of the Indian Parliament. Professor C. Rajkumar, who is the founding Vice Chancellor of Open Jindal Global University and the Dean of Jindal Global Law School.
We may elaborate more.
Professor Dr. Radhika Khosla, who is the Research Director of the Oxford India Centre for Sustainable Development, and Ms. Sara Kavil, who is also the Communications Manager for the Oxford India Centre for Sustainable Development.
Over to you.
Thank you for the introduction, Shivani. Welcome, friends and distinguished visitors. It's amazing to have you all at Somerville College and the Oxford India Centre. Here we are, being graced by such an extraordinary speaker about this wonderful anniversary for the Supreme Court. And we do love celebrating an anniversary, and you come to us in rather auspicious time for the Oxford India Centre, which is hosted here, because it is in fact the 10th year of the centre this year. So we couldn't be more thrilled than to have this event happening in our anniversary year, right here at Somerville with Dr. Abhishek Singhvi, who has spoken for us once before, and I know that you're in for a wonderful experience. I also need to say a few words about Professor Raj Kumar, Vice Chancellor Extraordinaire. I don't know a more dynamic Vice Chancellor in the world than Raj. He's been a wonderful friend to Somerville and the Oxford India Centre since its inception. And as I speak to you, I'm looking at our former principal, Dr. Alice Pahaska, who is here, and it is with Alice and Raj Kumar 10 years ago that we signed the MOU between Somerville and Birmingham. So we've had a fantastic collaboration since then. We've had students from Jindal Global come to us on immersive experiences here at Oxford. We've had executive education programs here with Jindal, and it's been a really fantastic. I always say the beauty is in the exchange, and it is wonderful to have Jindal Global's presence here every year. And indeed, some of the scholars of the Oxford India Centre were law students from Jindal Global, and some of the very best that we've had. So we have to congratulate Raj on his extraordinary achievements with the university. I think I just want to say one or two words about Somerville. I can see some of you are Somerville students, but many of you are not. So for any of you who don't know us, we were founded in 1879, and our mantra is we were founded to include the excluded. And as you may know, the excluded at that time were women. And we were founded in rather an extraordinary way, both to educate women at Oxford for the first time, but also as a non-denominational institution. And it states that as a non-denominational institution, we were founded with a progressive spirit, a pioneering spirit that was about openness and tolerance. And I think because of that, it is why a number of brilliant women from overseas came to us. And it was in 1889 itself that we welcomed the first Indian woman at Oxford. And aside from our scholars in the room, does anyone know who she was? Please don't speak, our scholars.
Of Cornelia.
Cornelia Sarabji. If you don't know about this woman, you should know. She came here in 1889, as I said. Not only the first Indian woman at Oxford, but the first woman of any nationality to read law at Oxford, and started this fantastic tradition. We're also known, of course, at Somerville to be the college of Mrs. Gandhi, Indira Gandhi, who came to study here in 1938. And so the Times of India recently described us as Oxford, India in Greenwich. And hence we have the centre. I could say a lot more, but I'm now going to pass over to Professor Radhika Khosla, who's our research director and climate scientist extraordinaire at Oxford, to tell you a little bit more about the centre before we welcome our guests. Thank you, Sarah. I've heard the history of Somerville in India so many times that it's like new. Every time we hear it. It's our privilege to have you here, to have our guests here. I'm going to spend a few minutes just talking about the Oxford India Centre for Sustainable Development, which some of you might know, some of you might have heard of, but let me just, say a little bit about why I think it's such a special place. So to begin with, it's probably the only centre on India at any global university that takes this focus on sustainable development in India. And in some sense, it was quite forward-looking because, like Sarah said, it's 10 years old that ambition came about. And the way in which we sort of think through what sustainable development means is to focus on 3 different pillars. So the first pillar is that of research. And when we think through our research and sustainable development, we take a very interdisciplinary and multidisciplinary view. So it is from looking at this question from the physical sciences to the social sciences to the humanities, and actually engaging on what sustainable development challenges and opportunities mean for contemporary India. For instance, there's work that is taking place on the political economy of electric vehicles, public interest litigation, the sort of, the development of antibiotic resistance, the development of solar cells. And so there's a sort of large gamut of topics that all of our scholars are engaging on that answer these really key questions about what it means for a country in transition to attempt to meet and develop across multiple objectives. The second pillar that we have is that of scholarships, and that's one we're very proud of. So Somerville is now become the home of the largest number of Indian scholars or Indian scholarships at Oxford. We started out with 3 10 years ago, and this year we have over 20. Many of you are in this room, and our alumni base of scholars is now over 50 students who have been through the Oxford system and are now, mostly back in India, working on questions of India and sustainable development. 2 of our recent scholarships that we're very proud of. One is the Opal Subramanian Scholarship, which has been given to one of our scholars who's working on rape legislation in India, particularly in the aftermath of the Verma Committee report. And much more recently, in fact, just a few months ago, we announced the Savitribai Phule Scholarship, which is a very special scholarship that is going to basically students from underprivileged communities, essentially focusing on Dalits and Adivasis. And this is the first of its kind scholarship for Oxford, but also for most universities around the world. And then the third piece of our sort of vision is this emphasis on impact and on outreach, which is being a bridge between academia and the world outside. And that essentially involves evenings like tonight, where we bring together scholars and experts and really incredible spokespeople from the world outside of the academy and outside of Oxford to come here and to be able to learn from them, engage with them, ask difficult questions. Tonight is a prime example of that. Last week we had Dr. Montek Aluvalia here talking about net zero and sustainable development. And it's through these engagements, especially during term, where we're able to build this picture of what is happening in contemporary India today, especially around India and sustainable development, how we can contribute, and what are the gaps that we can fill from being in this privileged position of being at Oxford. So I won't say more, but just to say that Raj and Jildan have been extraordinary friends and supporters, and we're so grateful for that. I'm always amazed at how you fill the room at very short notice, and I think that's testament to the community you have in Oxford, which even though you're far away, in Delhi. You have a whole sort of home over here, and we're delighted to be part of that. So I'll turn it over to you. Thank you.
All right. Thank you so much, Radhika and Sarah, for that very generous introduction. I want to begin by saying that it's an absolute delight for me to be here, because this place is very special for a number of reasons. Let me begin by saying that in 1998, I was a student in this university, and I was 24 years old, and I just, from the first few days of my life here, I began to think that how can universities be so inspiring and transformative? A question that I asked myself. It was a truly extraordinary experience. The intellectually vibrant environment, the strong commitment to research, the tutorial system, my own teachers and mentors who inspired me, who really, helped me understand complex issues of law. But more importantly, to be in this environment and to kind of absorb and observe what was happening in the world of education was truly amazing. In the first week of my stay in Oxford, I decided that I want to be part of an effort to build a university in India. And life, of course, came full circle, and next decade, student at Harvard, and then later as a lawyer in New York, and then taught in Japan, Hong Kong, and essentially had the opportunity to work towards building a university with many others. But I want to tell all the students who are present here, it is a truly life-changing experience and an extraordinary privilege for each one of you to be here. And especially, I want to come back to Somerville College itself. Way back in, there are two interesting aspects of destiny that brought us together. And I should tell you this, of course, Dr. Alice Pachaska, the immediate past principal of Somerville College, visited India early on with Sarah, and we had many plots and conspiracies to be part of an effort to build something here. And that, of course, came into fruition. And, both Sarah and Alice and Somerville, they believed in us long before the world discovered us. So we are looking at 2010. We had 200 students and one school, and we were talking about building a global university. And Alice believed in us, Sarah believed in us. And today, 14 years since then, we have over 10,000 students from 60 countries and 1,200 full-time faculty members from 50 countries. And this journey simply couldn't have happened but for the extraordinary trust and faith and belief in what we were setting out to do by people like Dr. Alice Pachaska and Sarah. And I want to thank both of you for being part of the journey. I also once I knew that the current principal, Baroness Janet Boyle, had visited our campus long before she became the principal. Yeah. And she was part of a India-US MP's program, and she came to our campus, and she was deeply impressed at that time, and she wanted to talk to me, and we discussed about, she said, why, at that time we had a number of British-US university collaborations, and she was very keen that why we were not building British university collaborations, and she was, of course, very keen for that to happen. And that many years later, she became principal here, and since then, she has also been extremely supportive, so I'm grateful to her. Of course, I want to thank Radhika Khosla for not only spearheading a very important institute here and to be able to be part of the thought leadership in advancing the cause of sustainable development and issues surrounding it, and to also be a great ambassador and supporter of our institution here. So thank you very much, Radhika, for all what you do for us. There are several people in this room, but I want to quickly mention a few people. I want to recognize the presence of Professor David Gardner, Fellow of All Souls College, a distinguished anthropologist. Again, David has been a champion of our institution and also a champion of India. I can't help but say that how much David did to, kind of resurrect the M.N. Srinivas chair here at Oxford, tirelessly working hard, engaging with government officials in Karnataka. And I could only see in my own eyes how much of commitment, dedication, conviction, and integrity with which he worked hard to be part of a cause that is truly selfless. So thank you, David, for the kind of work that you have done. I want to also recognize the presence of Dr. Barbara Harris-White, a distinguished development economist and India specialist. Again, a big-time supporter of our University. It's so good to see you here, Barbara. I also want to thank all the other guests who are present here. Sumit Sen, the fellow Rhodes Scholar, but also Manu, who's a lawyer from Madras and Court. So people have turned up from many parts of India, and of course, my dear students at my university as well. I want to also say that this has been possible because of this program that we have created. And since the program, we've had a large number of students coming to pursue master's education here at Oxford, not only in the law school, but also other schools, and of course, also pursuing a doctoral program. In fact, the transformative role of a university and education is truly visible when you have opportunities like this. So all I want to tell our students is that please consider this as a truly privileged opportunity that you have got. The pandemic has also taught us that how we can't take these physical programs where you're actually here and not in some Zoom call experiencing Madrid over television or computer, but you're actually here experiencing life in this very special, beautiful city. I also want to say that make the best use of the opportunity and to enjoy yourself and to bring back those learnings and those experiences. Let me quickly come back to why we are here. I want to take this moment to introduce one of India's most extraordinary lawyers and a truly amazing legal mind. I've had the privilege of meeting lawyers from across India and around the world. I can say with my full sense of conviction that there are very few people with this sharp legal mind and an amazing ability to grasp complex facts and law and to articulate in the most compelling and persuasive manner. No wonder, besides being India's most sought-after lawyer, he's also somebody who people are ready to pay anything to make him a lawyer from a kid. The good news is this, most of us in our life can never afford him, but it's not charging a single penny for all what he's doing. On a lighter note, I will say that besides being one of sought-after lawyers, he is also somebody who recognizes the fact that law has a very significant role in advancing the cause of justice. I must also mention that something about Dr. Abhishek Singhvi that many people may not be aware and doesn't publicize it much is that he's a very distinguished philanthropist and made immense contributions to a number of causes that transcend education and health. He's also a sitting member of parliament, and in that role, he has made numerous causes that benefit his own constituents and even beyond. But I also want to specifically mention and thank Somerville that even though he studied and got 3 degrees from Cambridge University, he has been allowed to come into Oxford and do this. I know that you made an exception to that, but I want to thank you for doing that. But thank you so much, Abhishek, for doing this. I know that our students will be deeply inspired by your presence. I also want to thank my dear friend, Honorable Mr. Justice Michael Wilson, former Judge Supreme Court of Hawaii, who is also present here. So you can imagine, we have people from the furthest part of the world, Hawaii, which is a small little island in the Pacific, to from Kanyakumari and Tamil Nadu in South India, and there are others here. So it's a very special moment. Enjoy the moment, and let us quickly move towards hearing Dr. Abhishek Singhvi speak on a topic that is so pivotal for the future of democracy. The title of his lecture is The Indian Supreme Court at 75, protecting rights, expanding freedoms, and empowering citizens. There is nobody better than Dr. Abhishek Singhvi who can speak not only from the standpoint of his long journey in law and his academic journey in issues surrounding law and justice, but also his public life as a member of parliament for 17 years as an MP. He has been fired by the Sabah. Over to you, Abhishek. Thank you.
Thank you so much for the very generous introduction. I'll speak sitting down. It's a cozy gathering. I think we'll all do it. Thank you so much, Raj, Sarah Khalil, Ms. Khosla, distinguished members, Professor Alice, Professor Yella, Professor Barbara, dear friends, Judge Mike Wilson from Hawaii, people from different parts of the world, advocates, above all, students. It is truly a great pleasure. It's been a few years since I last came here. But I was just telling Sarah that obviously Cambridge and Oxford have resonance across India for decades and centuries. But Somerville has really revived that connection in a more direct, continuous, consistent manner. Today, because of the exertions of people like Professor Alice, Sarah Kaleem, Ms. Khosla, and many others, Somerville is a known name. And through Somerville, Oxford has got that connection closer and closer to India. And Oxford being really a hyphenated word with Cambridge, Oxbridge has got that exposure additionally. So I think that's a very special thing done. Of course, the person sitting next to me, Vice Chancellor Raj, about whose dynamism I think you're all well aware. But what you're not aware is that the dynamism has many, many victims. Raj Kumar is a dangerous fellow to be around with. I have also variously referred to him with different appellations without his permission, including chief extortionist. The other day, I came across a very nice phrase about academics. Somebody said the difference or the similarity between a genie and an academic. Well, a genie grants wishes, academics wish for grants. But here's the man who actually extorts and extracts that grant. And he has amazing ability, and he's even able to get from his benefactor $200 million for the next phase of expansion during COVID time. So the next phase of expansion, we must imagine the kind of public good he has the capacity of doing. Of course, the other problem with this dynamism is that people can't keep pace, the blistering pace with him. I mean, I've been doing that for 3 days now. I'm thankful it's in lectures in London, meeting at Cambridge, now Oxford. So you have to remind him constantly that both Mike Wilson and I are older people. But friends, it's a great occasion to be with you all here. The topic advertised is, as you can see, the Indian Supreme Court at 75. And the three components which are sub-themes here, rights, freedoms, and empowerment, are obviously all inextricably intertwined. And it's best to discuss them holistically because they do really cross-fertilize and reinforce each other. They're not isolated, compartmentalized silos. And that's what I do, is dissecting them individually. But the golden thread animating all these concepts, as advertised in the topic, the philosophical ethic underlying them, all relates to the physical institution which binds them together, which has been repeatedly recognized as the great sentinel in the Indian context for expanding freedoms, protecting citizens, empowering persons in its 76-year journey. And it is no mean achievement that by and large, it has retained the highest trust quotient in India through vicissitudes, through ups and downs, through different periods of our tumultuous 76-year journey. It retains the maximum public trust. Of course, part of it is not necessarily because Supreme Court is remarkably over virtuous, but also because the others are far less virtuous, the other organs of state. But intrinsically, the Supreme Court also otherwise attracts that trust. Of course, we have signed as India various treaties and covenants in various years of our journey. But our commitment to these fundamental values, to the fundamental rights, to so many other constitutional values, predates all of it, right from the framing of the Indian Constitution. Itself a remarkable exercise over 2.5 odd years. And as somebody put it rightly, the famous American jurist who went through England and into India, fundamental rights were framed by the founders amidst the carnage of fundamental wrongs. And to even imagine the kind of contextual situation going on in the midst of this huge migration, and even more terrible carnage, for them to think of these values, to talk about them, to frame them, to debate them, and then to implement them, exercising restraint, plurality, inclusiveness, is quite a remarkable episode in their history, or for that matter, in the constitution-making history of any nascent country. Well, let me first focus on the Supreme Court. There are 5 broad critical features which evolved in that historical evolution, Supreme Court. Let me try and broadly and briefly itemize them. The first is its dual status, its dual role as an appellate court and also as a constitutional court. That need not be so. It is not so in many countries. The Supreme Court, of course, has multiple jurisdictions, including some original jurisdictions, some special statute jurisdiction. But maximum in number terms, it is an appellate jurisdiction, which means it deals with pedestrian, boring stuff like landlord-tenant issues, check bouncing cases. At the same time, it scales the heights of abstractness, of jurisprudence by dealing with constitutional issues, creative issues, cutting-edge frontier issues in larger combinations of 5 and 7 judges. And there has been a debate as to why the Supreme Court should diminish itself by dealing with such pedestrian matters, which obviously clog its arteries, though much less so than the other court system in India. But still, 60-odd thousand cases filed every year. 60,000 is a non-figure, inconsequential in the context. It's a humongous figure if you look at other apex courts across the world. So the debate has been, why should you not make it an absolute constitutional court and take away its appellate jurisdiction by having an intermediate layer court of appeal? But I personally believe that people who advocate that don't realize that a large part of the trust quotient, which I just mentioned, arises from this common touch which the Supreme Court has in daily issues, which touch the despised, the dispirited, the disappointed, who come with extraordinary hope to the court of last resort as far as they are concerned. So I think that abstractness, which is propounded, may well be counterproductive, because an abstract institution sitting at the top deciding abstract questions of constitutional law may certainly not have a similar kind of a trust quotient, which is a very enviable part of the Supreme Court's identity in the journey of the Indian democracy. The second facet of this journey of the Supreme Court in 75 years is its phase or periods of a Supreme Court as a positivistic court, but as a court which was deferential to a fault to the executive, a court which was timid and fragile and reluctant to assert itself. And the most obvious and the most egregious example of this is the emergency period. And we have had our EDM Jabalpur, for example, which is the counterpart of your Liversidge and Anderson, or the counterpart of the American Dred Scott. So, and in that case of ADM Jabalpur, the then Chief Justice, Ray, who led the majority, observed, quote, "Liberty itself is the gift of law, and may be by law forfeited or abridged." An extraordinary sentence compared to the kind of heights of judicial review which has now been scaled by the same Supreme Court. In that very judgment is the extraordinary dissent of H.R. Khanna, who is one of the few non-Chief Justices whose portrait rightly and deservedly hangs in court number 2. Dissent where he said, and the dissent asked him then and later, his Chief Justice, he said, "It is better that the independence of judges should be maintained and recognized than that unanimity should be secured through the sacrifice of that independence." He dissented a court of last resort. Then he goes on to quote Holmes on the brewing spirit, which is a famous quotation from Merrick. The New York Times on 30th April 1976, after that episode, has said this about the Khanna dissent: "If India ever finds its way back to the freedom and democracy that were proud hallmarks its first 18 years as an independent nation. Someone will surely erect a monument to Justice Khanna of the Supreme Court. It was Justice Khanna who spoke out fearlessly and eloquently for freedom this week, dissenting from the court's decision upholding the right Prime Minister Indira Gandhi's government to imprison political opponents at will and without court hearings. End quote. And I think his entire career has made that pro-liberty approach of Justice Khanna as the rule of the Supreme Court evolution, and not the rule not being the other way around. The aberration was the exception. Ironically, he was of course superseded, but ironically his nephew would be the next to next Chief Justice of India, a post which eluded him twice. The third facet of the Supreme Court is as a human rights and PIL court. And that really started with the post-emergency quest for legitimation by the Supreme. The abdication, partial abdication, or at least dilution during emergency led to this quest for greater and greater legitimation post-emergency. And you then had a constant increase in judicial activism, reaching its peak in Nadir. And it is now commonly accepted for many decades that the most judicially activist court, the apex court with the maximum power of judicial review, actually exercised day in and day out globally, not in South Asia alone, not in globally, from any country in the world, is the Indian Supreme Court. Without which say it would make the concept of judicial review of Marbury and Madison, usually attributed as the beginning of this process, would make that blush compared to the kind of judicial have now. And this third phase led to a whole range of PI jurisdictions which gave substantive directions. PI, you understand, public interest litigation, a purely Indian invention, an invention which does away with all the technical rules of standing, locus standi, allows epistolary jurisdiction, accesses increased humongously, and is supposed to reach and deal with injustices at the micro level, involving persons who are unable to approach the court or are otherwise deprived and rendered unable to approach the highest court. So in that phase, you had this repeated diverse examples of judicial activism. Directions regarding prison conditions of incarcerated prisoners, famous case of Sunil Batra in the late 70s. Cases of consolidation of PI and jurisdiction as a mainstay of decision making. The so-called Maneka Gandhi case, which established procedural due process in the Indian Constitution. It's called the so-called passport case. And now that journey has led to actually the introduction of substantive due process, something which our framers specifically rejected. Very much like the framers in US Constitution specifically rejected the concept of desegregation in USA. And yet you had Brown versus Board way back in the 50s, which brought it back. And in much the same way, you have now virtually full-blown substantive due process through cases like the Joseph Shine adultery case or the triple talaq case, and so on and so forth. And of course, the other part of activism is reflected in health and environment issues. So the emergency, in a sense, had the good blessing in disguise effect of being a wake-up call to a court which found itself diluting unnecessarily its identity, and then it therefore, with that wake-up call, moved fast and hard and big to refashion its institutional identity and imagination to focus on the three sub-themes of today's topic. We also, of course, had more recently the right to privacy, judgment, where the Chief Justice visited you recently, present Chief Justice overruled the judgment of his father in the 18th case. The fifth facet, the fourth phase was of the Supreme Court as a liberal institution and a constitutional court, led mainly by the current Chief Justice and some of his predecessors. And here they are zealously and jealously guarding the turf about independence of judicial. Clearly, a government which is in India, the first government in about 30 years to have a single party absolute majority. Willy-nilly, I would imagine every government, irrespective of political color, which has a majority, would flex its muscle to trespass on, coordinate other turfs, which is what was happening and is happening. The Supreme Court is very clear in trying to guard that turf and continue to have the last say, for example, in independence, in the appointment of judges, which they see as a ground and a basis to preserve that independence. Speaking truth to power, a phrase used by the judgments, has been the stated objective of many judgments relating to freedom and liberty. Freedom of speech and expression has been given special place. Sedition was reduced to vanishing point by judicial interpretation. Of course, ironically, it seems to have reared its ugly head again through a law commission report a few weeks ago, which has been largely disowned for the time being by the government. But so many other liberal, developing, dynamic processes, federalism is given prime position through judgments. Recently applied in a case which I had the privilege of arguing, the turf war between the Delhi government and the centre. The judgment came in favour of the Delhi government entirely based on federalism. Again, something which the framers did not quite intend India to be as federal as it is in operation now, or as judicially interpreted when it is now in federalism. Then, of course, the most recent, on which I've had occasion to speak, partly today and in London, the same-sex marriage issue, which the court willingly took up, despite it being a volatile cocktail of, limits to judicial review, judicial creativity, political issues, emotive issues, psychological issues, etc. But the court has gone into it and we now await the judgment reserved, expected in July or August. Safeguarding rights and expanding freedoms, clearly the most glorious moment for the court in the overall context of this 75-year journey was in 73 when it asserted the basic structure doctrine, a doctrine which is a purely Indian invention. I would say now the pride of India and the envy of many other jurisdictions, but clearly a bulwark, a permanent bulwark against constitutional tyranny and dictatorship. It's a remarkable doctrine which in one sentence says that even a constitutional amendment can be unconstitutional. Something so simple and yet so powerful. And a constitutional amendment passed by the requisite 2/3 majority of Parliament can still be unconstitutional if it violates the so-called basic features of being a constitution. And secondly, the basic features of the Indian Constitution shall be decided on a case-by-case basis by the judges themselves, which means that the final arbiter of saying what is the basic structure remains the judges and no other arbiter. There is already a very impressive laundry list of basic features developed by individual judge-made law. Federalism is now part of basic structure, democracy, one man, one vote, republicanism, independence of judiciary, the power of judiciary. All this has been case-by-case skeleton part of judiciary. So that tomorrow, for example, as has happened many times in the constitutional history, or indeed the wrecks and ruins of constitutionalism which litter the South Asian landscape, It has happened frequently that the most despotic regimes have done that despotism and assumed power through a completely valid constitutional amendment. Saying, for example, tomorrow that India shall not be a republic, but shall be a monarchy. But that would be a constitutional amendment. No problem with the system of amendment or the constitution itself permits it. But here we are constitutional. So, on the whole, I believe that to take a larger view, the court has reflected deftness, adroitness, nimble-footedness in this handling this maze of different situations, and has, despite of course periods of negativism, periods when there has been direction in application, on the whole, acquitted themselves creditably. Let me just have a quick survey of some other cases, because this is, and then come to the larger issues, because Indian Supreme Court at 75 really has to be seen contextually in Indian democracy at 70. Before I come to that, you've had this activism reflected in so many other diverse situations. You had, for example, third gender status for transgender people established, a whole range of civic rights or consequences from which third gender people will thrive. The daily irritants of life have been recognized as being available to them, and they should be entitled to it. There has been interpretation of the Information Technology Act to prevent or minimize intrusive prejudicial action in terms of what you do and what you write on social media. It's a different story that recently, after many years of this Shreya Singhvi judgment on information technology, the court lamenting the fact that in actual fact, cases are still being instituted by prosecution, despite the court's ruling many years ago. So that is another aspect to India which you must realize. The executive or the police or the people who harass you know that the law is already decided, but equally know that the British system of common law, which all the common law countries follow, the process can be the punishment. So ultimately you will win your case, but you might suffer sufficient harassment in that process of appeals and counter appeals, and in India in particular the delay. So it is good enough because it's an individual case by case decision making process. So despite guidelines being laid down by the apex court in case A, in case B and C and D, in the length and breadth of this vast country of India, you may still file cases which ultimately will be held to be violative of that judgment A. But by the time it is so headed, there has been enough suffering caused by the process. And that is the tragedy of many of these situations, including the Information Technology Act, including the sedition limitation to vanishing point. As I said, of course, that sedition, the government at the moment is playing cagey, saying something which nobody seems to believe. And this is an independent law commission initiative to find out and to write a report. We never commissioned it, we never knew about it. I think nobody except the government believes that. But at least at the moment, it is not law, and the current set of interim orders by which sedition, filing of cases of sedition has to be kept in abeyance is the law of the land. What happens after and in what manner this law commission report is taken up will have to be seen. There has been a third area of empowering citizens through the technique of creating a judicial fasciculus of a framework where the court sees it as an unoccupied territory. And what I mean by that technical phrase is that the prime example is sexual harassment cases at the workplace. Governed till today for many, many years, despite now almost 20-25 years, by a judgment which laid down guidelines on how to deal with sexual harassment in the workplace, called Vishaka. Now that was a clear advance in the law. They did it on the basis that we cannot traditionally legislate, but yes, you have no existing framework So we are occupying the field till such time as legislature steps in. The legislature has not stepped in at all the last 25 years. So the judicial judgment of Vishaka continues to hold the field. And perhaps it suits everyone because there is a lot of flexibility in the joints where it will be covered by judicial guidelines. It is in that sense, therefore, edifying and uplifting to know that the apex court of a country continues to have this central role and the trust portion that I talked about. But equally, it is saddening that in a democracy, the other organs of state have that much lesser and lower trust portion. And the very positive approach towards the Supreme Court underlines and illustrates the fragility of the vote of confidence in the other organs. And that, I think, is not a very good comment on Indian democracy. Some of the negative results in the larger context of Indian democracy, of course, arises. And obviously the court on judge-making, law-making by judges, or lawyering in a democracy world's largest, cannot be seen in an isolated manner out of context without seeing the larger picture of democracy in India itself. Obviously, that has diminished and suffered because of scourges or vices, like, for example, the one growing criminalization in public life. Now, I'm not one of those who goes by bare figures because a lot of the figures really involve petty offenses or offenses which are both agitational, political transgressions, which are not really, I would say, criminal offenses, more serious sense. But there is no doubt that the number of serious cases involving those in public life is also increasing, and that's a matter of great concern. A recent figure shows that there are at least 1651 major cases related to murder, kidnapping, and rape charges across the length and breadth of India against members of parliament and members of state legislation, which is a pretty high figure considering the seriousness of the offence involved. The second part of this diminishing democracy facet is, of course, the issue of corruption, which, though we've talked about it a lot, we've not really been able to deal with it effectively. And India continues to languish in the, for example, the Transparency International Index, and somewhere broadly where it has been for a long while, 85 out of 180 in the Transparency International Index, and similar positions in other indices which have dealt with this. The third is the fact that the independence of judiciary is constantly being threatened. And it's not, it is of course both from within and without. Both are serious, but those within are always more serious. From within in the sense that some indifferent appointments in the hoary past ultimately gravitate to the senior positions. And that gravitation leads to prior heavy political commitment, a predetermined judicial philosophy, a religious proclivity, and so on and so forth. And it needs only 5 to 10% judges to be having deviant characteristics to be a huge spoiler for that particular court or institution. You don't need every judge to suffer from that vice. And I think that is a consequence of some years, indeed decades, of indifferent or poor or deliberately wrong appointments. That is something which is vital for the larger issue of judicial independence and institutional integrity for this institution of 76 years. And unless that is addressed, we will find daily examples when this come from within, they are much more difficult to police and control. There is a conspiracy of silence. There is an incestuous cloud which does not permit you to deal with these threats from within in the same way as you would be able to otherwise. Equally, of course, there are threats from without, from external sources. Now, the threat is not that somebody writes a letter or they say that Angela Khan. to your face, judge, and do this. That's not the way. So it's difficult to say, why do you criticize? Because you have no proof. The real fact of the matter is that there are enough indirect ways of conveying messages. There are enough obstructive delays or practices which will adversely and prejudicially affect the career of judges, which will send a message to a few judges and which will make the large majority act as a huge deterrent to independence with that large majority. And that, unfortunately, is also happening when, obviously, you have a government which has such a majority that they would not be comfortable with an external pushback by an external organ. And there is always an attempt to be able to occupy part of that space or overall control. Now, again, luckily, this is a clear exception. It's not the rule. But there is no doubt, and I would be less than candid and probably quite actually probably indulging in a certain degree of falsehood to say that the climate of fear has increased. Climate and the ambience of inhibition, hesitation, fear has increased. Not necessarily by direct threat, but by a whole complex ecosystem being created where boldness, independence, and bluntness is not within any encouraging manner. As we end, we see the Supreme Court at 75 as part of Indian democracy, friend. So let me just take a few minutes more and step back and consider Indian democracy. I'm now not limiting myself to the Supreme Court, although that is the topic. Dealt with that, both by case law, both as an institutional evolutionary organ, and as a body which has an identity very powerful and distinct by itself. We are now looking at Indian democracy as a whole for a few minutes. And one of my favorite ways of dealing with that is to ask a question of both Indian and foreign audiences, which I have asked. And that is that consider a most remarkable thing. It's a very simple question, but still a remarkable facet of Indian democracy. Consider that between the 1930s, roughly, and the 1960s, a large number of countries emerged from the yoke of imperialists, some 30, 40 countries. Dutch imperialism, British imperialism, French imperialism, Portuguese, so on and so forth. And they are across Australasia, Africa, South America, Pacific, so many places. But I know India remains the only one of those to have remained a vibrant democracy post freedom from colonialism. That's an extraordinary statement of fact. I mean, there may be one or two small exceptions I may be missing, but certainly nobody remotely the size, diversity, and nature and character of India is anywhere seen as a vibrant democracy having emerged from that imperial context. And therefore the question is, why? And I have no satisfactory answer. If you force me to answer, my most candid answer would be sheer good luck. The second answer, if forced to give a more analytical answer, would be that also again by good luck and by God's will, we possibly got the sequencing right. The sequencing which had Gandhi before Nehru. Because there is hardly anybody you can think of who would have got us independence more effectively, have forced it in a non-violent manner, than the world's greatest agitational politician in that century, Gandhi. But equally, it would have been a disaster had Gandhi been the first Prime Minister of India. We also got the Nehru at that time. And Nehru, who was, for all his faults, and today's, as I said, today's dispensation context considers that Nehru was only a person full of faults. That certainly is not true. But even conceding that Nehru, as all human beings are, was full of faults, he was an innate Democrat. There is no more person suffused with inherent democratic thought processes than Nehru. Of course, even if he was a bit of a left of center, over-romantic, over-idealistic, trusting, plebeian socialist, but he was clearly a man who believed in democracy. And he epitomized Voltaire's phrase that I will disagree with you completely and violently, but will defend to death your right to disagree with me. And that Nehru thereafter lived long enough was another part of the icing on the cake. Some of our neighbors had untimely demises in their legions. I think we did Southeast India. India was lucky it had a 17-year prime ministership of Nehru. And that helped in creating a series of non-institutional and institutional pillars of Indian democracy, which Nehru nurtured and strengthened and evolved and developed. But the third aspect of this question is, would the reverse sequencing have been equally good? I've said no. Gandhi, the excessively idealistic, reclusive, inflexible, morally obstinate person that he was, could never have been able to manage the pulls, the pressures, the compromises, the flexibilities required to run country, a nascent, independent country emerging from the yoke of business. So as I said, this is the secret source of a good jugalbandi, which we got in the right sequence, is possibly the larger picture of Indian democracy, which is frequently missed out. The second aspect of Indian democracy at 75, which also is missed out, is to recognize, underline, and appreciate the several non-institutional pillars of Indian democracy. Even more important than the several institutional pillars, both of which have converged to make India a vibrant democracy, despite, of course, the aberration that might have. And this is not a time and place to deal with those non-institutional or institutional pillars, but clearly the first of them, in a very quick, as I say frequently, I'm doing the job of fan dancer, touching upon the topics without really covering it. So, but it's important to mention that. So first of these pillars, the non-institutional pillars, is secularism, something which is a self-preservatory ethic in a country as in planet Earth's most diverse spot, which is India. There is no spot more diverse on planet Earth than India. And as we know, 22 scheduled languages, 700 mother tongues, 2,000 dialects, the largest population of 4 religions originating here, the world's second or third largest population of minorities like Muslims, the bewildering diversity of races, sounds, smells, foods, dresses, rituals. So we're doing nobody a favor by practicing secularism. You're actually doing something which is the only way of keeping such a bewildering diversity together. And I've always found Professor Rajiv Bhargav's definition of democracy most useful. He has so many, not so much. And he said, former Harvard person, he said, we want to understand why Lincoln said, by the people and for the people, which is a wonderful definition. See, why do you say of the people? It's a very strange phrase to use. And then he answers his own question by saying, of the people is supposed to convey a sense of co-ownership of democracy as co-partners in democracy. And secularism is nothing but that, when it says that inclusively all communities, religions, persons, individuals should get a sense of belonging, of co-ownership on that piece of cake, which we call democracy. And unless you're able to impart that sense of co-ownership and belonging to that cake, then you are not really fulfilling that secular ideal. The second non-institutional pillar is related, of course, the word which finds a place in our Constitution. Secularism entered the Constitution 20-25 years after independence, till not there in the original preamble. But fraternity was very much there in the preamble. The much undernoted, underlined word but a word which is of great significance, very much similar values as secularism, and pluralism and inclusiveness is the heart of that word, fraternity. The third, of course, is federalism, another non-institutional pillar, but a very valuable vehicle to manage diversities. I look upon federalism as a pressure cooker in the kitchen, which manages the diversities like dissent, discomfort, dissatisfaction, the 3Ds, and prevents a conflagration or explosion at the top. It allows, like a safety valve, a lot of these things to settle at lower decentralized levels. So it's a mechanism to quarantine conflicts at regional, sub-regional, local levels and preventing a national conflagration. The fascinating story, for which we have no time today, is how, in typical British mold, we design a very unitary constitution. Not only the British, but even otherwise, we're very scared about the fissiparous tendencies of a exploding subcontinent in 47 to 49 partition. We were worried about India remaining together as a nation, so we designed a very unitary and a non-federal constitution, which the Australian jurist Kenneth Weir called quasi-federal, basically unitary with some small concessions to federalism. But the fascinating story is how a largely unitary constitution designed like that has become, in actual operation, hugely federal and decentralized in operational reality, leading to this nice phrase written about accidental federalism or inadvertent federalism in India. And that is another story about fiscal federalism, linguistic federalism, federalism through judicial review, federalism in governance of states, and so on and so forth. But that is clearly a third important non-institutional pillar of Indian democracy, within the context of which the Supreme Court functions. The fourth pillar is, of course, parliamentary democracy, where it is not really democracy, but the word parliamentary. And there, you need to have something beyond just the building, which you call a temple of democracy, or just a great structure. You need to have the spirit of parliamentary democracy, which is why I say that we've been fortunate. Of course, Nehru was the archetypal parliamentary democracy today. Could not have been a better example. Somebody who gave it. But the successors, in particular Vajpayee and Manmohan Singh, have believed in parliament. Vajpayee, you will be surprised to know, was prepared to give up all party posts and willingly gave up presidentship of the BJP for many decades, so long as he was kept leader of the opposition in the House. Because for him, parliament was uppermost. And that trait is fundamental. I don't have time, but as I've said, how to describe parliamentary democracy, the best way is for you to come to Central Hall of Parliament, or at least what used to be Central Hall. I don't know what the new Parliament holds for us. But the world's biggest gossip spot with very, very economically priced food, but showing true independence and freedom to speak what you like, say what you like, in a multi-political spectrum context. It's 10 different parties, individuals sitting in chairs across. And anything and everything you say is up to record. So, that of course is a spirit we have to keep alive. I don't think the two ladies in Bangladesh can do that in their central hall. I don't think Nawaz Sharif and Zia have could do that in their central hall. And I think that central hall spirit is important. And I hope it stays. The fourth other major non-institutional pillar is, of course, the press and the judiciary is the fifth. We've already discussed the judiciary. There are, of course, institutional pillars, which are very important, apart from the press, the Election Commission of India, the Indian Army, and the Comptroller and Auditor General of India. These are things we take for granted. And it's very important to take institutions like the Army for granted. They're there in the backdrop in a less gender-conscious world compared to the Parda Machine lady, who's the anchor of the house, but she's not seen or heard much. And that's the anchor which you need. The moment you start seeing and getting the army, you can firmly believe that's the beginning of the end. But these are very important institutions nevertheless. and attempts to intrude there or compromise institutions are very, very insidious, more so when they are covert, indirect. The other thing we have to remember as we end is the scourge affecting the judiciary itself. What is hunky-dory with the judiciary? And unless we recognize that and underline that, we cannot just have self-congratulatory pats on the back and just say that it's a great institution. There are many, but the three I have identified as I arrive are the scourge of arrears, pendency, backlog. A court with the best and the brightest minds in the world, and I'm not talking the Supreme Court, I'm talking the judiciary, a pendency pre-COVID of 30 million and post-COVID of 40 plus million, 42 million, right? There are about 10 million just over the COVID period. All the sermons, all the lectures, all the great glittering doctrines, avant-garde, in all respects, all the judiciary cannot explain that, excuse that, condole that. And that is what makes us hang our head in shame. All the seminars, lectures, and reports from working committees cannot get rid of that inconvenient fact. And something I've written about a lot, spoken about a lot, it's a subject matter, can be subject matter, 2-hour lecture, reformers with special justice. And there are many reasons, but many of them are very simple. And it's sad, for example, to just end on this part by giving one example. You were at no point of time in Indian independence for 75 years have you had more than 2/3 of the 1100 odd high court posts filled. In other words, 1/3 of all posts out of 1100 in a country, of course, a litigating public, I would imagine about 200 million. 1/3 of the posts have always been vacant at any point in time. How do you expect patients to be treated with excellent hospital buildings and equipment without doctors? The other issue is integrity issue, something which we tend to brush under the carpet. The very fact that it is the highest trust quotient institution makes it obligatory upon them to devise a transparent, effective, and accountable sadly there in no such system. We have an in-house mechanism, but it is very incestuous, very opaque. It inspires no confidence and trust. And unless some harsh measures are taken from within, because the worst kind of accountability would be the external check on this. That could include upon judicial independence. But unless the judges themselves take step, also I should might see, they are actually endangering their independence, which is the basic object of all this. And the third is the independent judicial, which as I have already explained, has to meet with threats from within as much as without, sometimes more from within, sometimes more from without. There is clearly something which on the whole till now the court has managed. But I really hope and trust that it continues to be so. And you have to do this while speaking truth to power and preserving your independence. I ended, this is actually, it's not a lawyer's ending, it's a promise, it's an actual ending, with 3 very good positive features in this legal system of which I've been a part since I joined practice. Seems perfect. And that should be of some optimism for people like you, the youngsters sitting there. The 3 remarkable optimistic features which give me a lot of hope for the future are the contrast with when I joined the profession. Number 1, from being a refuge of last resort, law has become an option of first choice. So today, you do not try the civil service exams and fail, and don't try 2 or 3 jobs or self-employment and are successful and very still, now let's do law. It is actually an option of first choice. It's quite remarkable. You might take it for granted, but not when you rewind to when I joined. You would actually come to it if not the last, at least the second last resort. That itself is a vote of confidence, and you've been there for all rest assured that you are barking up the right tree. Second is that persons unconnected with the law are joining in larger and larger and larger numbers. Gone are the days of the ancestor and the law-based family, the uncle, fathers, grandfathers, etc. There are, of course, examples of that, and they seem to be overemphasized. The reality is that the largest number of people are joining have no connection with law. And I gave the example in the other lecture. There are many examples of both architects' children, doctors' children, engineers' children, with a very strong push away from law, joining law. But the most remarkable example came with a leading industrialist, a top industrialist of India. This is a true story. I won't name it. Came to my house, and 2 minutes later, his son straggled in. And he says, look, Abhishek, I'm here for a very strange thing. I want you to convince this madman not to join law. I have such a large industry. I have a own business, and he's bent upon joining law. So I'm the first person to come to you not to advise and guide my child about law, how not to join law. So this gives you actually an apocryphal example. The chap is still doing law in Colombia. I don't know whether he joined or but I don't think his father allowed him to join, but he's still actually doing law in Colombia. So this is a very, very good thing that it all happened. Never happened in our times. And third and last, and I see that as usual, ladies possibly outnumber men here, is the remarkably good being which ladies are getting at all levels of the profession. All means all except the very top. It is true that it takes some time to gravitate, and you all started late. So there is no doubt it's about to happen. It's taking a little longer. At the very top, leaving aside that very top slot, at immediately number 2 levels, and of course 3, 4, and 5 levels, there's an explosion of ladies. And they are doing very well, as a lot of you and your friends will find out or have already found out. And that again is an extremely good sign. And I have no doubt that the very top class ceiling I'm talking about is in the process of being reached. So I think in the end, we have to be thankful for what we have. We have to consolidate what we have. And we have to keep adding, keep improving, keep creating an ecosystem where the values we've talked about today keep on progressing. And I have no doubt that Indian democracy, which has survived such vicissitudes, will attain even greater heights as long as an institution like the Supreme Court continues broadly in the trajectory which it is about. Thank you so much.
And that's what I think again. Thank you, Dr. Abhishek Singhvi, for that comprehensive tour de force. And I know that it is so amazing that it covered so much ground in a very short span of time. We are running late for dinner, but we won't let you leave without a couple of questions. So let's have a few questions before we leave. So introduce them. Keep it short, but because of the paucity of time, I'm going to take 3 questions and then have them answer and one go. Please.
Thank you so much for the talk, sir. I'd like to get your thoughts on public interest litigation and how it interacts with the traditional idea of adjudication. I'm asking this in context of your writing in the Somerville case, where you said that the people who are actually aggrieved were not represented before the court. And what do you think can be a mechanism to address that parallel of public interest litigation?
Okay, great. Number 2. All right, let's have somebody from behind. Please.
I'm Gaurav. You touched upon the role of judiciary in environmental protection. I was wondering if you could speak about how do you see the role of judiciary moving ahead with climate change particularly?
Okay, great. And third, please.
I just want to know your thoughts on what you think is the relationship between the central government and the Supreme Court from 1975 and right now.
Okay, all right. You have 3 to answer.
Okay. Sabarimala is a large question. It's a matter I unmute. and lost 4-1. Interestingly, with the lady judge dissenting in my favor. It was then overturned by a review being allowed. As it only used a 99% fatality. This was allowed. And it is now pending as a sub judice matter having been revived. So that judgment is under reconsideration. It's a difficult, I don't choose my clients and I don't judge my clients. It doesn't mean that everything I represent I believe fully. But I think that we, on the one side, have been able to make out a case justifying exclusion of women. On the literature abroad, and we can talk about it for 1 hour. I can try and convince you. They're very interesting legal arguments, but it's not possible to do so in the time available. I think we have to await this. It's a very emotive case, but I take literally 1 minute to do something which will take hours otherwise already. The central theme of the argument is very different from what is publicized in the press. It is based on the guaranteed right of religion under Article 25. And it goes something like this, to oversimplify it very quickly, that this involves a right-seeking approach to the only deity out of 1,500 deities of Kartikeya across India. Kartikeya, as you know, is one of the sons of Shiva. This particular one is the only one which is depicted in the form of an eternal celibate. It's called Neshtik Brahmachari. And therefore, there is a reasonable nexus of the exclusion of women of a certain fertility age from accessing a manifestation of a god which is inherently based upon eternal celibacy. And the second aspect of this is that, of course, we do not exclude because below 10 is not excluded, above 50 is not excluded. So there's a rational basis that fertile women are supposed to shield the god of eternal celibacy. And that has been the tradition. And that is a sufficient valid classification under Article 40. It gives you an idea of how interesting law can be and how seemingly hopeless propositions do have another side. As we say, you have to wait that. And I think these are decided as much as by the technical law I explained as by English. And I am no ways of knowing which way it will go, but we are hopeful in that there is now, and you'll be surprised the poll was taken at that time. Not that polls matter, I don't think so. Overwhelming number of women, 90% versus 10%, want to vote for continued exclusion. Now that's much larger debate and I'd love to have it sometime else. The other is environment protection and climate change. Well, the most activist, the most fearless, the most open judicial activism, consistent and sustained, has been by the Supreme Court and environment. There have been no dips and vicissitudes. Been a consistent, ever since we started a Green Court some 40 years ago. It has been a upswing. We attained new heights of environment. All the three principles of polluter pays, intergenerational equity, sustainable development, we see to be all kinds of unimaginable contexts. In particular, it has been comprehensive in terms of different forms. So forests as much as rivers, as much as waters. The one area which is not being directly dealt with this big mega issue is CC, climate change. That's interesting. Not because the court is hesitant, but because it has not really come to the court. And I think it is very fertile ground to start that line of jurisprudence, especially by global citizens like Judge Wilson sitting here and a committed climate change person, activist, who has a global view of the India, the China, the US situation, to generate a certain awareness and a initiative which then ultimately will find its way into courts. Because ultimately the mega declarations and the mega principle is of no use unless it is manifested in the dialectics of adversarial litigation, where it actually bears fruition in individual cases. So I expect that the next phase of environmental litigation in India, in the decade starting now, will be focused more on climate change than it has been. The earlier ones have been basically forests and these three principles that I just said, polluter pays, intergenerational equity, and sustainable development. And civic issues. of cleaning up the Yamuna or the Ganges and things like that. The third question, well, it's partly a political question, but I think the correct answer is that the emergency, of course, was wrong and was an aberration, but remember, it was a constitutional aberration. Most people forget that word, that prefix before the word aberration. Actually, my PhD thesis in Cambridge in emergency powers and legal analysis, and a lot of political analysis, the legal analysis of 4 jurisdictions, America, England, India, and international covenants. But once you realize the 1970s emergency as a constitutional aberration, you have to say that it should never happen, but if it happens, it should be a constitutional aberration. Perhaps what you are seeing frequently, and I don't want to sound political, I'm using words of studied moderation, but perhaps what you see in the recent past are far greater aberrations because they're undeclared. They're unconstitutional. They are not constitutionally sanctified. They are not circumscribed or boundaried by the various constitutional limitations which a constitutional declaration of emergency requires. So the phrase is not mine. It's been there in the press for the last 10 years, 8 years. Undeclared emergency. And perhaps an undeclared emergency is more dangerous than a declared.
All right, let's take a couple of questions and then that's the last round. All right.
Thank you, Dr. Singhvi. You spoke a bit of judicial activism. Could you comment perhaps on the potential for South-South collaboration or perhaps convergence with other global South jurisdictions?
For what's now South collaboration, how our ports can inspire other folks. All right, next question, please.
Hello, sir. My question is with regards to, so the Supreme Court has increasingly been taken so to cognizance of important national matters. So what are your thoughts on that, whether it's intervention, whether it's highly whether it's very significant in nature, or should the Supreme Court scale back on those?
Try this one more. Oh, yeah. Last. Okay. Oh, well.
So what do you think would be the role of the Supreme Court in terms of developing jurisprudence for religious protection, especially in the context of the views of, let's say, the dominant political forces today?
Well, let's take the middle one first. Quantitatively, you shouldn't be surprised to know that quantitatively suo motu exercise is not very large. As a matter of fact, suo motu may not be that relevant. Of course, it is there, and it is exercise once in a while. Something shocking, something urgent and immediate. But it is exercise very sparing, much less so than a lot of others. It has become less important because PIL is a far more efficacious vehicle, rendering suo motu largely unnecessary. Before the judges can blink, there is a citizen out there who takes up the PIL cause of the issue which would otherwise might have been suo motu. Might have been so. So I think the PIL and the diversity of PIL pretty much covers most issues which the judges might have wanted to take up so. So it's not a major issue. The third question, religious protection, is a very large question. Articles 25 and 30, I can't discuss in 30 seconds. All I can say is that it is important for the court to address the difficult issues arising. I happen to be part of a lot of the major ones involving religious. And unfortunately, the decision not to decide or the decision to put the decisions at cold storage on both days. So we have Sabarimala, which we discussed pending. Luckily, it has become less emotive now, but it could have exploded into especially in the south, a major cultural. But equally pending are Santhara, which I appeared in, the Jain practice of allowing yourself to pass on to death. How distinguished, how different it is from suicide. These are very complex questions, not understood fully. It's very easy to start prosecuting people for suicide. without understanding the Jain concept of Sankhara. But the point is not my saying so or not his saying so. The point is the court has to decide this to give definitive quietus. Pendency is not good, creates uncertainty. The third aspect is the larger issue of what is and what is not part of the essential religious practice. That is the heart of the question you're asking. All the questions arise on whether you answer the question that this is part of the religious practice or not. I mean, I have the strange distinction of many of the more unpopular ones. I'm appearing another pending matter on the case which justifies khatna, the practice of the Bohri community to do incisions on the vagina, as an essential part of religious practice, as being justified or not under the Indian Constitution. Again, that is pending. That our counsel of this side or that side is not relevant. The point is, these have to be decided, without which you back up. There is an earlier batch of the 50s and 60s which have settled one set of law principles. For example, the chap, remember the Anandamargi sect said that, look, I have the right to take a procession out annually. I have a right in that profession to carry a trishul, which is a 3-pronged spear. And I have a right to play damru, a small drum, and dance on the streets of Calcutta. Why? Because all of these three are my essential religious rights, which otherwise is protected in Article 25. So the court has it. We've examined it. First of all, we don't even find that Anand Marg is a religion at all or a religious practice. The Radnaya sect is not part of the essential religion. 2, even if it was, there is no right to dance with a trishul or with a damru on the streets. It's not part of essential religious right. But whether or not, so therefore it's decided clearly this side. But whether or not other things are essential religious, for example, the barka case, the burqa case, is it part of the essential religious practice? The headscarf case. These are matters which are very emotive issues. They need to be decided. These 3, along with the headscarf case, are the 3 major pending ones, into which I happen to be appearing in fact. And I think it's important for the court to settle this, because in especially a diverse context like India, these need definitive. And you'll be surprised how people who are otherwise emotive and charged and disagreeing will agree willingly once the Supreme Court decides. That's the meaning of a trust quotient. They don't agree with the judgment, but they will settle down in their quietus. Why? Because he has not decided that the executive, she has not decided the legislature, but the judicial organ will decide. That's, I think, a big thing, which is why it's all the more obligated to decide. The first question on South-South, I'm not quite sure what you mean, because South-South is more an executive government-to-government initiative. The best way I can answer your question is that courts do not come in most of the systems you're thinking. They will in some cases. In most of the systems you're thinking about, they don't come under the executive control. In correct elections. So the executive in a South-South dialogue, and our former Prime Minister was chairing the major part of the South-South dialogue before he became Prime Minister, Dr. Manmohan Singh. That dialogue is inter-country, international, regional. But in all these inter-country, regional or international dialogues, the judiciary is not a part, because it's a separate, independent organ of state. The better way to look at it is by organization, one of which I've had the privilege of chairing and being president of. Regional, voluntary, non-governmental organization of associations of lawyers, judges, and law persons. And one of the most famous at one time is now voluntary disuse was SARC Law, which is the Association of Lawyers, Judges, and Law Persons, Law Teachers, and Judicial Persons of the SARC region, the countries of Nepal, Pakistan, India, Bangladesh, and so on. And it's purely voluntary, and we are founder member. I became a president of it. I mean, we had a lot of useful discussion on the subjects you're saying, but that's not the same thing you're saying. It's a South-South discussion.
All right. Well, first of all, I really want to thank Dr. Singhvi for not only for that beautiful lecture, but also the questions. Thank you to all the students and all our participants. We've run out of time. I want to thank you and all of you who are invited to join us for dinner, which is being served. I believe it is already getting cold. We are running late, so we'll move there. Mike Wilson, you have 1 minute to say whatever you wanted to say to the students. Please, over to you.
Aloha.
from Hawaii, and I've had the privilege of being with a lot of you at Jindal. I just want to let you know this very brave group called The Final Stand, who are the students that are standing up for the climate change issue, will be having a meeting when we have a wonderful conference coming up October the 1st to the 12th. So get ready, stay tuned, and we have a couple of members here that will be giving you the information about when we're going to get together and have our seminar on climate change with The Final Stand. So aloha.
How was that? Was that a minute? You did very well. Thank you so much, and this program is ended. Thank you.